those questions. So we're going to get started about another 15 seconds, but we will get. All right, so I see the first question there. We're going to you will certainly, by the end of this, you will certainly know the answer to those questions. Where do you get started? All of that kind of stuff. But we'll we'll touch on that a bit more. So, and I see your questions coming in. This is good. Don't have any value that really need a will. Oh, that's a really good question. If you don't have anything of value left behind, do you really need a will? I give you the quick answer now. Absolutely. I'll try to circle back to that and answer why and make sense of it when we go. I do a ton of presentations. I was just at 2 different churches over the weekend, and I got that question, which is, if I don't have anything, do I really need this? So, really good question. What I need to include now that my children are nearly adults? That is also a very good question. So we'll circle back to all of that. We'll do that one towards the end. But let's go ahead and get started, you all. I'm excited about this. I've been doing this presentation, or at least, well, this presentation for years. I've been presenting for the Win of Color Task Force Conference also for years, and I love presenting here. I love doing this and sharing this information. I do feel like it's my mission to make sure this information is shared everywhere. So I go everywhere I can trying to share this, because what I found is that a lot of people don't approach this in the right kind of way, including lawyers. I've had a ton of people come and tell me what another lawyer told them, what their friend told them who's a lawyer or financial advisor. And it is not uncommon, or I guess I should say it's very common, that the information that they share from other individuals is very incorrect. So I feel like it's my mission to get out here and share this as much as I can, so I can kind of correct some things. But let's get into that. I'll talk more about that. Now, lawyers always have a disclaimer in almost everything that we do. Nothing that I share here today is legal advice, and you are not my attorney, my client or attorney. I guess there's 1 or 2 people on here that are clients of mine, but you are not a client of mine. Certainly not because of this presentation. Now, you might decide you want to call me after this and we work together, but please don't take anything I'm saying today as legal advice for you and your situation. I have to see your situation very specifically, and something I'm saying today, though it's true, I'm only going to share truths with you today, it may not be the best for your particular situation. So I'd have to see what's going on, and then I can make a very specific recommendation for you. Nonetheless, I'm glad that you're here, because we're going to be able to cover some things. My first point, my first purpose of doing this is I want to make sure, like I said earlier, that you have proper information, period. But I want to give you that information in hopes that I can inspire you to lay a foundation for your strategy. As you'll see in a second, I believe that this discussion, this topic, this information is among the most important things you'll ever do or consider in your entire life. And part of the purpose of this presentation is to convince you of that, because it is that important. I'm the guy who gets called when a crisis hits home. As I'll explain in this presentation, I had some major crises hit last week with clients. I'm the guy who gets called when that happens. So I see the results of not having this stuff in place, or not having it in place correctly, and having it in place correctly. So I do want to inspire you to make sure that you take care of everything, period. Yeah, so any questions that were asked anonymously, maybe we can touch bases with those towards the end as I open it up for questions, and maybe you can read them off to me at that time, Vanessa. So thanks for that message. But the third thing I want to do may sound interesting to you. This, as you'll see in a couple of slides, this work deals with stuff that is not fun and enjoyable to talk about typically. Nobody wants to sit around at a dinner table and talk about what happens when you die, or what's going to happen to you if you become incapacitated. Nobody wants to talk about those things typically. Well, I guess I do, but most people don't want to talk about those things. So what I'm hoping to do is help simplify the process. I don't want to sound like some stuffy attorney who's teaching a law class, but I also want to make the process enjoyable in the work that I do, but even in the sharing of the information. So hopefully you'll find both of those things today. Now, as we get there, here's the slide I've been waiting to get to. What questions do you have? You've already started putting your questions in the chat. Continue to do that throughout this presentation. Try not to ask a question during the presentation by unmuting yourself. Let's not do that, just because since it's Zoom, it gets a little awkward. If we were in person, I would do that for sure. But I will definitely make it a point to deal with as many of the questions as possible towards the end. So I just put a little list over here to kind of jog your memory or get your juices flowing on this topic. Is anything on that list spark an interest in your mind? If so, put that question in the chat and we'll deal with them for sure as we go, or towards the end at least. Now, everything that I do as an attorney, as an estate planning attorney and a probate attorney, deal with these two major questions. I do believe that these two questions are two of the four most important questions that everybody will deal with at one point or another in their lifetime. There are only two questions in all of life that I think are more important than these. And again, I'm going to try to lay the case in this presentation for why these are so important. But the first of those two questions is this. It's kind of obvious. What happens to your stuff when you're gone? So I want you to think about that. And I don't want you right now to think about your mom or your uncle. I want you to think about yourself. And I know I said this is going to be fun and enjoyable, but this slide may not be so much. But we got to deal with it. And I want you to think about this. If you were not here tomorrow, if you did not wake up tomorrow, and we know that that's very possible. I'm not trying to scare you for life and death purposes, but I do want to show and highlight the urgency of this discussion. So if you weren't here tomorrow, what would happen to your stuff? Whatever you own, no matter how much or how little, what would happen to it if you weren't here? Or your children, if you have children, certainly if they're minors, but even if they're adults. Somebody has already asked a question about what do I need to do regarding adult children? What would happen if you were gone? The second question, though, is similar, and people don't always think about this, but it's just as important, if not more. If you suddenly couldn't make decisions for yourself tomorrow, who would make decisions for you and what would they decide? Now, imagine that. If you woke up tomorrow and could not understand what was going on, if you woke up tomorrow and didn't realize who you were even, who would begin to handle money for you and property and business? Who would begin to write checks? Who would decide where you can live and what you should eat and how you would be cared for? And maybe more important than who is the what would they decide? Are you sure they would do it like you want them to do it? Now, when you really think of those questions the way I phrased them, you see why I think these are two of the four most important questions you'll ever deal with. Yeah, you can consider your job as important, where you work or how much money you make or, those kinds of things, where you live, how your house looks. But all of that can be happening perfectly. But if you wake up tomorrow and don't realize it, what's more important? What's going to happen to you or what's going to happen to those things? The point is, we got to deal with this. Now, what I've learned and seen is multiple over the years. I've seen a lot of different studies that deal with this question. And what we're learning and what's been consistent is that about 70% of people don't have a plan in place. Which means in any room that you're in with 10 people, out of those 10 people, only 3 of them probably have a plan in place. And I'll say, I'll up the ante a little bit. Out of those 3 that probably have a plan in place, the reason I say probably is because from experience, I know that probably 75% of them don't have it in place correctly, or it's so outdated that it might as well not be in place. So really, in my opinion, I'd say maybe 10% of people really, truly have a good plan in place that deals with what they want to have happen with those 2 questions in the way they want it to happen. And that's another part of the key. So out of what we're learning, one of the things that was interesting to me that this slide shows is that young adults are now more likely to put something in place than middle-aged and older adults, which is interesting. Of course, for years, the older people, retirement age, and not old, I didn't say old, I said the older people who are like retirement age on up, they typically would have plans in place more, but we're seeing those numbers change. And I haven't studied why lately, but that's an interesting concept. So why don't people do it? A lot of people just say they don't know what to do. Like there's a question here, I don't even know where to start. A lot of people say that, and I get that, which is why I do these presentations, and which is why I'm glad you chose to show up for this presentation. Many people come to me and say they just don't have a whole lot. They don't think they need to have anything. We see that question has already occurred as well. What if you don't have a lot? Do I need to do anything? And then a lot of people will say to me, my family knows what to do. Or when my mom passed, me and my sisters, we knew exactly what to do and we did it and everything was fine. Well, when you really think about the gravity of those two questions, it really raises an additional question. Do you want to leave yourself, your stuff, and your children to an I don't know, I don't think I own enough, right? Or to a you all know what to do, just take care of it. I don't think that's a good move, which is why we do this. Now, when we look at my family here, we look at this picture here, these people, if that guy in the front with the bald head, if he was no longer in this story, what would that mean for the other three people if he had not planned correctly? And then, I mean, can you imagine the stress that could potentially be left on their faces? Um, and then what if the guy and the adult woman in this picture were no longer here and they hadn't planned correctly? What would that mean for these two young ones who we say we love so much? Yes, I am pushing. I used to say I'm not a pushy attorney. I am very pushy these days. At this point in my career, I feel like I need to be, especially when it comes to this stuff. So I am saying this is a very big deal. This is not a deal that you want to put off and think about and wait till you get everything together. This is something that needs to happen now. Quick story. Last week, we had a client who called and had been given, 7 days to live, and she was in 2 days. Already 2 days of those seven had passed, and I went on an emergency basis. Went and met with her the next day, and I've been talking about this with my staff. Went and met with her the next day, and pushed my staff to get her plan done in 24 hours. It usually takes about 3 weeks at least. Went back over there during the ice storm last week and signed her plan, and she did pass the next day. And in her family, there's such a big twist, a lot of twists and turns going on with her assets that if she hadn't gotten that plan in place, it would have been chaos starting now. Fortunately, it's not. And when they called me to tell me that she was in her last couple of hours, I said, well, everything is now taken care of. Go ahead and spend time with your mom in these last hours that you have with her. Don't worry about any of this stuff. Once you're ready, we'll be able to take care of business in the way that she wanted. And they felt fantastic about that because they didn't have to worry about this stuff. This stuff is extremely important, which is why I'm doing this presentation today for you all. And I believe, which is why you're here listening to it. All right, so let's keep going. We got to talk about this stuff. It's time to have these conversations. Yeah, it's hard to talk about it. Yeah, it's hard to deal with it. We have to have these conversations at the family gathering, just when you stop by to see mom or wherever it is. We got to talk about this stuff. And people wonder, how do you raise it? I get the question all the time, how can I start this conversation with my parents? One answer is just start it. Just jump in. That's the kind of person I am. I just jump in and ask the question. I mean, come on, the elephant is in the room. Let's at least identify it as an elephant. Now, we might be nice to the elephant, but let's identify it. There are other ways, though. If somebody puts that question in the chat, I'll be sure to circle back to that later on and talk about it. What I like to do is dive into real life scenarios. I don't like to just talk about legal stuff because even I get bored by that. I get to train attorneys these days. I speak all over the state for sure and around the country, and I get to teach attorneys about how to build a practice and how to do this law and all of that stuff. And one of the things I tell them very plainly, remember, I just jump in and go right at it. I say to them, you guys are boring. When you're talking to people, they're typically bored because all you're doing is talking about law and all this boring stuff. They don't want to hear that. So what we're going to do today, because I don't want to be bored with my presentation, we're going to look at real scenarios, many of which you've probably experienced, or you might have some of these situations going on right now for you. And then I'm going to break it down for you, and I'm going to show you whether I see that situation as being good or bad or both. And then I'm gonna, sit it with that and tell you different ways to resolve these things. So let's jump in. Let's look at the first scenario here. This guy came to me, and by the way, all these scenarios are real. These actually happened with me. So Stacy's dad decided that he didn't want to do a plan. He said, "Listen, I'm not married. I have one child. Stacy's my daughter. I want everything to go to her anyway. So, Terrence, why should I waste money paying you? You attorneys are always trying to just make money. Why should I waste money paying you to write a plan that's going to do the same thing that the state is going to do if I don't have a plan?" And before you consider whether he's making a crazy decision or a good one, let me shed some light on this. Now, he's right that Michigan does have laws in place that govern what happens when you pass. If you pass without a plan in place, that means that you have passed intestate. You've died intestate. Michigan intestacy laws, and every state has intestacy laws, say exactly what happens to your stuff when you're gone. And so he's saying, I know what Michigan intestacy laws say. They say everything's going to Stacy anyway. So why should I waste time planning with you, Terrence? It just doesn't make sense to me. Let's see. Let's see what Terrence thinks. Let's see how Terrence answers that question. Well, I tell him that you absolutely need to do a plan. And the first and number one and main reason, and this lays a foundation for our whole discussion today, Stacy's going to be in probate court if you don't. Well, what's the problem with that? Well, probate has a time, cost, and publicity problem. Most of the time when we consider probate, we're thinking about how people fight all the time, and it's maybe chaos, and judges and lawyers are involved, and they're eating up all the money and all of that. And I can tell you that that's very true. We have a very strong probate practice in our firm. When people pass, or if somebody becomes incapacitated and they don't have things in place correctly, or when people are fighting over the assets that somebody had, probate court deals with it. Those cases come to us and we have to go through that process with them. And so we know firsthand of the drama that's involved in those cases. But even in cases where the families don't fight, probate still has these three components that people want to avoid: time, cost, and publicity. Probate takes about 4 to 6 months by rule before the case can end. It takes about a year on average for the whole case to be completed. But then if people fight, it'll drag on beyond a year for sure. That's what's going on in the Aretha Franklin case, by the way. She passed about 5.5 years ago. And unfortunately, she didn't have a good plan in place. And they've discovered these 3 wills, and the families are fighting over these 3 handwritten wills that she had put together, fighting over details of them. And then there's some other issues going on as well. We're 5.5 years into it, and that case is still going. That's one component, though. Cost. Probate court costs about $300 to open the case altogether, between different fees that you have to pay. Attorneys are going to charge you anywhere between $3,000 and $6,000 for a regular, straightforward, nobody's really fighting case. In the event that somebody does fight, that cost can definitely go up. Definitely will. Not can. It definitely will go up easily into the 5-figure mark, 6 figures even, depending on the case. By the way, Chadwick Boseman, Black Panther, a part of his estate had to go through probate court, and at the end of it all, his wife had to pay about $1 million out of his estate to the court, and between courts, the court and attorneys and things. So it can definitely get up there if you don't plan correctly. The third factor, though, which is the one that people probably don't like the most, the reason I can talk about Aretha Franklin, the reason I can talk about Prince or Chadwick Boseman or Larry King or Anne Heche, is because their probate cases are completely public. Probate is a completely public proceeding. If your assets go through the probate process, then you're pretty much guaranteeing everybody that they can learn about your information. And so you probably don't want that to happen. They can find out about what you owned, all about your debt. They can find out about your children, including their addresses. And they probably can find out who got everything. All they got to do is go to the court and pull the file. If your estate goes through probate because you haven't planned correctly, people will be able to find that out about you too if they want to. Some say I don't care because I won't even be here. So what does it matter? Good point. Maybe it doesn't matter at all. I know for me, I wouldn't want all my business out there. And maybe more importantly, like in Prince's case, I'm certain he wouldn't have wanted the world knowing about his sister's drug abuse situation. But because it went to probate court, the world was able to discover that. So that's something to consider. If you don't care, maybe Stacy does. Maybe Stacy doesn't want her business in the street. Well, if you do probate, it's going to happen. Guardianship and conservatorship is what you pursue if you need to get authority over a living person to be able to handle their medical and housing decisions. That's guardianship, or to handle their money and property. That's conservatorship. Those are two separate cases which aren't fun, because you have to first prove to the court that your loved one needs a guardian or a conservator by telling them what you can and can't do. And that's not fun, sharing that business. And then number two, you have to beg a judge to appoint you. And the judge may not appoint you. I've been involved in many cases where the judge appointed a lawyer or a company to stand in that stead. That's probably not what you want. If you don't plan, that's probably what you're going to get. Let's go to the next scenario. Doug's mom added Doug to her bank account and her property as a joint owner. So this is the scenario where the parent adds the child or sister or whoever on the account so they can transfer money back and forth pretty easily, so that they can handle business for you if you get older or can't do things as well, and so that they get everything when you're gone without probate court. And what I can tell you is that in the perfect world, this is definitely a great scenario for all of the reasons that we just talked about. So I know I would even bet you, if I had to bet, I would bet that half of you on here are in this situation in one way or another. So it makes sense. I know why people do it. I used to be in this situation. The question, though, is this a good solution to do it that way? And you may be surprised to discover that I say no. And I typically push people away from this. Now, again, this isn't legal advice. In your situation, I might say, you know what? Yeah, go ahead and leave it that way or do it that way. But most of the time, I'm saying no. Why? Well, first of all, because Doug in this scenario now owns that asset or those assets. This means that Doug can take. What does this mean? The guy who used to train me in this, he had a client. We used to do these presentations together, and he had a client named Charlie, who he would talk about right about now. Charlie had built a nice estate for himself. He had all kind of properties. He had all kind of money and vehicles and everything. Well, Charlie's daughter graduated from college, from high school, and decided that she was going to go to college in Florida. Charlie had a property down there. He said, I got an idea. Why don't we put your name on that property so that you can get in-state tuition purposes? Worked perfectly. They did that. She got in-state tuition. It was great. She moved into the house. Well, everything was great until she met boyfriend. And boyfriend and Charlie's daughter started doing bad stuff on Charlie's property. Well, Charlie didn't like it. And Charlie said, you know what, daughter, you got to stop doing that stuff on my property. She said, no, I don't, Dad. I'm grown. And he said, well, you got to stop your grown self from doing that stuff on my property. She said, Dad, I can do whatever I want to do on our property. He said, well, I tell you what I'm going to do. I'm going to go down and take your name off of my property. She said, wait a second, Dad. I'm the only person who can take my name off of my property. And she was exactly right. When he made her a joint owner on that property, he can't take her name off of that property anymore. Only she can sign a new deed removing her name from that property. So that's one reason why you want to be very careful if you ever choose to do this before adding anybody's name to your asset. But I know exactly what you're thinking. You don't put the bad child on the account. You put the good child on the account, right? Well, what if the good child had a creditor that they owed, got into an accident? Maybe they're great with finances, but they got in an accident, had a judgment against them. Or maybe they aren't great in finances, and so they owed somebody some money, and that creditor came collecting. Do you know, because you made them a 100% owner of that asset, when you made them a joint owner, you made them 100% owner, that creditor will look at that the same way and take that money? Now, in both of these scenarios, can you prove, A and B, can you prove that that money is really yours and it wasn't intended for Doug to have it? Well, of course you can. But you're going to be trying to prove that in court. First of all, how much is that going to cost to do that? And then secondly, you might lose. That's another reason why it's probably not good to add anybody as a joint owner. The creditors can take it. Third, is there a tax issue? Now, I'm not a CPA or tax preparer, any of that kind of stuff. There's probably a CPA or tax preparer on here right now. I'm not going to deal with this. I'm just going to say you want to consider the tax ramifications of adding that person on to that account. and you want to talk to a tax person so they can help you consider that. Most people don't do that. I wonder if they're setting themselves up for a bad situation. Lastly, Medicaid. If you ever need Medicaid to cover your long-term care, and I'm going to touch on Medicaid, I think, for a minute. I'll go through it kind of fast towards the end, but if you ever need the state to cover your long-term care costs, this joint ownership arrangement is going to impact that. Right about here is where I always tell everybody, never, ever, ever add anybody to any asset of yours as a joint owner other than a spouse, maybe. Now, I will tell you, sometimes, as I said earlier, I might recommend to people, I might tell you, go ahead and do it that way. But as a rule of thumb, generally, I say don't do it. It's way too risky. Let's go to the next scenario. Single mom and guardianship. I'm gonna go through this one kind of quickly. Karen is thankfully divorced from her husband. She has sole custody of their minor children. Her mother said, listen, I'm gonna take care of those babies. If anything happens to you, forget him. I got your back. And your sister says she'll help me if I ever need to do that. Can Karen truly rest in peace? Can she truly move forward knowing that everything is covered correctly? I'm going to say not so much. I think that's very insufficient. She needs to do something much more formal to make sure everything is taken care of correctly. Why? Well, first of all, I know some of you are thinking Dad's going to get his kids, right? So they can't just take those children from the dad. Well, they've never really stayed with him. Well, if he shows up, says he wants them to, the court is probably going to do that, unless it's proven that he's unfit to parent, which is a high hurdle, a high burden to deal with. But let's say that does happen. It gets even tougher because you know that life insurance, maybe that house or bank account that you set up and saved and moved, taking their dad off of, for example. And by the way, I don't just pick on the guys. This can happen the opposite. It might be the dad. Maybe he doesn't want the mom to do it. I just want to do that for my brothers who aren't on here. I know. I'm on Zoom though, so I can't get in trouble with you all. Anyway, he's going to get his kids. And guess what? All that money that you left for the kids, guess who's going to have complete control, most likely, to manage it all? That's right. You took him off the life insurance. You did all of that. But if those children go to him, and if they're the beneficiaries of that money, he's going to be the one managing it because the court is going to require that somebody manage the money before the life insurance and all that can pay out to those kids, period, up until they're 18. And then when they're 18, as you hear about later, they're going to have the right to take all of that money, whatever is left over from dad handling it. Probably not the best task. There's a much better way. And by the way, for those of you thinking, it's not to add your sister as the beneficiary for the benefit of the kids. Because when we go back to the last one about joint ownership, the rules still apply. First of all, she doesn't have to use it for the kids if she chooses not to. I know she wouldn't do that. She's the good sister. Secondly, though, her creditors can take it. Third, what if she passes before it's all gone for the benefit of the kids? Then it's going to go to her heirs. Maybe her children or her husband, and then all other reasons are the same. This is insufficient at best. It's insufficient, kind of like trying to cross this water on that bridge. Let's go to this next one. This one gets fun. George and Gertrude were married later in life after previous marriages. They have children, no children together. They have 5 adult children. He brought 2, she brought 3, and they have no kids together. What does this look like from an estate planning perspective? Is this a good move? She said, we need to do a trust to make sure everything is handled correctly. Is she right or not? I know most of you are probably thinking, yes, she's right. And I'll tell you, I think she's probably right. Now, there are other ways to do it, but a trust is probably the best way to take care of it. The broader point is the urgency that's embedded into their scenario. The single parent of the minor child is the first of 3 categories of people who have to plan yesterday. The stakes are way too high for the reasons that we talked about. The blended family is the second of 3 groups that have to plan yesterday. And here's why. First of all, if one spouse dies, the majority of assets transfer to the surviving spouse and then to the surviving spouse's children. What am I talking about? Let's do it in example ways. So when I first got started practicing law, George and Gertrude came in and sat down right in front of me. They had 5 children between them. One of his children had passed. He only had a daughter living. The wife, Gertrude, she still had 3. This is very early in my practice, years ago. Well, she sat down and she said, Attorney Quinn, you got to know right from the top. We need a plan right now. We got to do something right now. And somebody referred us to you. We're ready to go. Please help us. I said, okay, no problem. Well, what are you thinking you want to accomplish? She said, well, there's something you got to know right from the top, Attorney Quinn. And you got to get this really clear. And that thing you got to know right from the top, Attorney Quinn, this is a true story, I promise you all, is that we don't like our children. Now, it's not my job to judge. I kept a poker face because I didn't want them to think I was judging. But inside, I was like some of you just where I was like, wow, really? She said, we don't like our children. And she said, there's something you got to know, Attorney Quinn. We don't want our kids to get anything when we're gone. I'm talking about nothing. We don't want them to get anything. This is a true story, I promise. She said, we want everything to go to our grandbabies. But she said, but we don't want those kids touching it. And for sure, Attorney Quinn, nothing can ever go to his daughter. And she looked at him and said, ain't that right? And he just said, He didn't say too much. So we started talking about how this could work. And she had stepped out to go to the restroom. And I wanted to hear the guy talking. He hadn't really said too much yet. And so I said, Mr. George, are you sure that this is what nothing to the kids and whatever? He said, you know what, Attorney Quinn? He said, she's right. We aren't too excited about decisions our kids have made. And we don't think they really should get our stuff. She doesn't like my daughter because my daughter didn't visit me when I was in the hospital. They haven't been right since. And he said, but I really would want to leave my daughter something. I wouldn't want to leave here. And she see that I didn't leave her anything. I said, inside. I didn't do this outside. I knew it. Well, started talking about maybe leaving her a car, $1,000 or something. Those were drops in the bucket for them. Miss Gertrude came back in. She said, absolutely not. No, we're not doing that. No, I've already said it. We're not giving any of the kids, and definitely not his daughter. We're not doing it. No. Well, they left. A few days later, she called. She said, Attorney Quinn, stop everything. Don't draft anything. Stop, please stop. And she said, she said, George is talking about he wants to leave that girl something, and I refuse to do it. I am not in agreement. No. So don't do anything right now because we can't agree. Well, I didn't do anything with their plan, but I did send them a letter. And the letter said something like this. Mrs. Gertrude, I want you to understand something here. I said, I understand you don't want to do anything, but imagine this. Just hang with me for a second. If you passed first, do you realize everything will go to your husband? And by the way, that's not 100% true. But for now, let's just say that's true. It's almost 100% true. The majority of the stuff will go there, but whatever. Everything's going to go to your husband. I said, and then if he passes without a plan in place, where do you think everything's going to go? It's going to not only go to the level where you said you don't want any of them getting anything, but it's all going to go to the one person who you said, not over my dead body, his daughter, because that's what happens in blended families. Let me do it a different way for you. Mom and dad get married. They aren't mom and dad yet. They have kids. After that, the kids grow up in this house that they built. This is mom and dad's house, and they built this house. The kids grow up, graduate from school, go to college, start their families, move out the house, everything's good. Well, let's say that years later, mom passes and dad then years later remarries, moves mom number 2 into their mama's house. They live in that house. And then let's say dad passes a few years later and mom 2 now owns their mama's house. And then a few years later, mom number 2 dies. And under Michigan intestacy laws, their mama's house goes to mom 2's kids. So they're watching their step siblings living in their mama's house. Now, I'm not trying to create trouble. I'm not trying to put a black cloud over blended families. It's wonderful, it's excellent, and all of that. I'm just trying to highlight why it is absolutely crucial and essential to plan if you're in a blended family situation, because you're setting yourself up or setting your family up for chaos and conflict without planning. Not because you're a blended family, that's not why you're setting them up, but being a blended family sets them up if you don't plan. You have to plan now. Blended families, the second of 3 groups that have to plan immediately because you're looking for drama for your family if you don't. Let's move on to this next scenario here. This one is the last scenario that I'll share for now. The Parkers had wills and powers of attorney prepared. Their wills say, take care of our child who has a special need. Here's who we want you to appoint as guardian if we're not here. And then with our rentals, just sell them or distribute them and make sure everything is used for the benefit of our kids. Now, here's what I want to tell you. Probably the most important purpose of doing any kind of plan in this realm is to make sure we know what you want it to have happen at a time that you can no longer tell us. We need to know your intentions at a time that you no longer can express them. The reason you use an attorney who specializes in this area, please don't ever use well, I don't want to say it that way, though I mean it. I encourage you to only use an attorney who truly specializes in this area. It does not have to be me. Let me make sure that's clear. I'm not saying it because I hope all of you hire me. I do hope you do, but that's not why I'm saying that. I'm saying it because in addition to writing it, you want to make sure it's written in a way that everybody, including a court, will trust and believe that that's what you wanted. Part of the problem in the Aretha Franklin case is she hand wrote her wills on her own. Now, you can do that. For those of you who are curious, yes, you can do a handwritten will. And yes, they can work just fine. We do a presentation every other month on probate work, and we talk about a case where a guy hand wrote his will and everything worked extremely well because he followed all the rules. I don't know how he knew them, but he was thorough and he took care of business. So it worked. Now, I'll tell you something about that in a little while on the next slide, but still, we knew what he wanted and nobody could challenge that. But in this case, is this a good situation that they've done these wills and have laid all this out? Now, in person, I would have already told you that there's at least one trick question that we're going to deal with. And right now is when I would help you discover, let you discover that this is in fact a trick question, because the answer is both yes and no. You probably already picked up on why part of the answer is yes. And that's because at least they've done some kind of plan. At least they do have a will in place that says what they want. And let's even say it was drafted by an attorney who does estate planning. That will expresses their intent and probably won't be challenged successfully as they're dealing with it. So at least we know what they wanted to have happen. But why is it mostly no? Well, the answer to that question is, number one, probate is still involved. I know many of you are concerned and worried about that because that's a surprise to you, as it was to me after law school when I got trained in this area of law. I don't remember learning this in law school. And as I often say, I might have been asleep that day in class. However, I don't remember talking about this. When I discovered that a will is only for probate court, it shocked me because I'd always been taught that a will is how you avoid probate court. But that's not true at all in any situation. With a will, if all you have is a will in place, you're promising your family that they are going to go to probate court. And the reason is because a will is nothing more than a letter to the court saying, here's who I want to be in charge of my case. It used to be called executor. Now that person is called a personal representative, number one. And number two, here's who gets everything after the time, cost, and publicity of probate court. So a will is nothing more than a letter to the court. You need more than that for sure if you want your family to avoid probate court. Write that down. Double check it if you don't believe me. You'll see that I'm telling the truth. Second reason is, should that minor get everything? Now, aside from the issue with the special need, should that child get everything that they want? Well, no, of course not. And honestly, the court isn't going to let everything go to the child right away anyway. The court is going to require that a conservator be appointed to handle that money for that child. As we talked about in the single dad situation, even if the person is the parent of that child, if an asset comes to them from somebody else, they're going to have to do it that way. But let's add in the issue about the special need. What happens there? Well, glad you asked. If you end up leaving an asset to a child that's able to receive governmental means tested support, like Medicaid, for example, then you're probably causing them to be disqualified, because those assets that you left them will probably be greater than the $2,000 number or whatever the number will be for that child limit that they're able to have in assets. There's a much better way to make sure that child with a special need can both benefit from your assets without also being disqualified from that governmental support. And it is not what this scenario provided. One other thing, what about the rental property? Why did I put that on there? Well, people often have property in addition to their home. And most of the time, I'm encouraging them to make sure that they put that property in some kind of liability limiting vehicle, like a corporation or an LLC. LLC stands for Limited Liability Company. Why? Tree falls on somebody and kills them. Their family hires Jeffrey Feiger to sue. He sues for $100 trillion. And the court awards them, let's say, 10 million. You have insurance on the property, hopefully, maybe $200,000. There's still 8.8 million. Is that right? There's still money left. Still $2 million. There's still $8 million left. That's due. Do you know that they can collect that money and will collect that money against everything else that you own? Whereas if you have it in a liability limiting vehicle, all the same rules apply. If that liability limiting vehicle was created correctly and then operated correctly, which your attorney should be able to walk you through, all they can take is what's owned by the LLC, for example, which is the property probably. But beyond that, they shouldn't be able to come through that and take your other assets. Most people don't do that. Or if they have an LLC, they just got the thing from the state and got a tax ID number from the IRS, but they didn't check all the boxes that need to be checked to make sure they're insulated from liability. What does a complete plan include? Now, everything on the left side of that page, numbers 1 through 4, are oftentimes in the complete estate plan. Now, let me say this right from the beginning. There are a lot of attorneys who run around and will only do trust-based plans for you. And mostly because you make the most money on trust. They definitely cost more than a will-based plan. In both plans, you get numbers 2, 3, and 4. In a will-based plan, you only get 2, 3, and 4. You don't get the trust. And the 1 through 4 plan that involves the trust typically costs more than twice the cost of a will-based plan. Having said that, there are many people who I recommend just wills for. Once I sit down and look at what you have going on and what you want to have done, the decision for me is not only based on how much you have in assets, but also the types of assets and how you want things involved or distributed. So don't think that if all you have is X, Y, or Z, you definitely don't need a trust. And don't let anybody tell you that who hasn't done a thorough look into your situation and who truly specializes in estate planning. But having said all of that, if it weren't for the cost difference between a trust-based plan and a will-based plan, I would be known as the guy who is only going to do a trust for you. I would never do a will for anybody alone, except in a very limited situations, because of what we talked about on the last slide. A will is only for probate court. And I know you don't want your family going through probate court. So why would I create a plan that's definitely going to do what you didn't want to have happen? Only time is when it looks like in their situation that it's the best recommendation. What's the difference between a will or a trust? When I do these in person, I ask your questions at the beginning and I list your questions out. It's a little different on Zoom. The number one question is always, what's the difference between a will and a trust? And I know some of you are probably nodding right now. I can't see you. Probably nodding right now saying, yeah, I got that question. Fundamentally, the difference between a will and a trust is what we just talked about. It's probate court. If you want your family to stay out of probate court, then most likely you will want to have a trust created. It's not just for people who are rich like Oprah Winfrey and Bill Gates. Trusts are for everyone who wants to avoid probate court. Although we may do something different. Again, I got to look at your situation. That's the fundamental difference. Now, the trust only keeps everything out of probate court if 2 things happen. The first is you have to create the trust correctly. That's my job as the attorney. Oh, excuse me. The second thing, though, is similar. While you're alive and able, or equally important, while you're alive and able, you have to properly connect the stuff that you own to that trust. I create the trust for you. Think about it as a big bucket. That's step 1. Make sure you hire a bucket building specialist. Step 2, while you're alive and able, put your stuff in the bucket. The trick is the second that you're gone, you don't want anything left in your name. You either want it automatically paying out to people via beneficiary designation or paying into a trust so the trust can govern it by funding that trust, by putting the stuff in there while you're alive and able. I can build the best trust bucket for you in the world, but if you then don't connect your stuff to the bucket in the right kind of way, you've pretty much wasted time building the trust in the first place. But if that's the case, that's where number 2 comes in. You still do get a will with a trust, but it's a special will called a pour over will. Its job is to catch that asset that you didn't put in the trust, you didn't listen to me, or you never got around to it. Catch that asset, take it through the probate process, and at the end of that process, that will pours that asset over into the trust bucket for you. We don't want to use that will for that reason because it means probate court happened and we're trying to avoid it. But in the worst case scenario, it covers your back and puts that in the bucket. Number 3, powers of attorney. That's the document. The power of attorney is the document where you give somebody authority to handle money for you while you're alive, money and property, write checks, all that for you while you're alive, but need or want somebody to. That's what allows your family to avoid having to get conservatorship over you, a validly drafted and executed power of attorney. Your healthcare power of attorney goes by all these names at number 4. It's the same idea, but it's where you give somebody the authority to make medical decisions for you. A complete plan oftentimes does and should include numbers 1 through 4. On the right side of the page, these are just some additional considerations. That special needs trust is probably what you should have in place for your child if your child has a special need and could receive governmental support. That's a way to make sure they can still benefit from your assets without losing that governmental support. I don't think I said it. The family with the child with a special need is the third of 3 groups that has to plan yesterday. And it's because of that reason you don't want to disqualify them. Now let's do this. I'm going to go through this quickly because I want to make sure I get to you all's questions. Let's talk a little bit about Medicaid and long-term care for those of you who may be caring for a loved one or just may have this stuff on your mind in general. What do you do? How do you deal with this? What's the ins and outs of it all? Again, I'm going to go through this quickly because this is really designed more to cover the stuff we've already covered. I just decided before coming on, I was going to give you all a little bit extra and add this information as well. So how do you pay for it? If you need to go into a nursing home, that's what we're talking about. And when I'm working with people in Michigan or anywhere else, they often tell me, yeah, I got long-term care insurance. And I say, well, my job provides it. Well, no, they don't. Not anymore. I haven't really heard of it being provided. What you probably have is disability. That's not what I'm talking about. I'm talking about insurance that you purchase that will cover the cost of nursing care, skilled nursing care, or a nursing home if you ever need it. Of course, you can pay out of your pocket privately, but right now the average in Michigan is about $8,000 a month. So what I push and encourage people to do, and I don't sell it, is to get a long-term care insurance policy. It's expensive because long-term care is expensive at $8,000 a month. But it's one of those things where if you need it, you really wish you had it. So consider that. Consult with a long-term care agent. If we meet, I can put you in touch with people who I know, or just find your own and have that conversation and get a quote. And if you can afford it, I typically encourage people to go ahead and buy it. There are other government programs like VA benefits if you're a veteran or married to a veteran. And then Medicaid, which is what people often think about when they think about needing nursing home care, having the government cover the cost. So let's look at Medicaid. Medicaid is a federal program that's administered through the state. So it's a program set up for you to be able to qualify or try to qualify to have the state cover your nursing home care costs when you don't feel you have enough assets to cover it yourself. It's not Medicare. Medicare is really health insurance. It's insurance that covers doctors' bills and prescriptions between the different Medicare plans that are available. And typically you get that almost automatically when you reach age 65. All right. Medicaid, however, and there are multiple types of Medicaid. For purposes of today, we're going to talk about nursing home care, skilled nursing care, Medicaid benefits. That's usually only available to people who are low income, which is why you have to have little assets in order to qualify for it. Let's look at what that looks like. How do you qualify for Medicaid? People often ask me, aren't they going to take my mama's house or something like that? The government is not taking your house. There's not a Medicaid lot of houses where they take your house. So that doesn't really happen. But what does happen is if you don't prove to them that you cannot afford to pay it yourself, you just don't qualify. They just say, no, we won't pay for it for you. In order to qualify, There are three tests that you have to pass. The first test is, do I need it? The second is an asset test. The third test is an income test. So when we talk about the do I need it, that's kind of easy. Your doctor can write a letter saying that you do need it because you can't handle your activities of daily living or enough of them to not need it. That letter is the first step in getting qualified. The second is the asset test. And you see here on the screen, it says you can have no more than $2,000 in assets. And I know most of you are thinking, well, hey, we never qualify for that because we got 2001. I'm just joking with that, but you get the point that I'm making. But it is true. If you have $1 over that, you do not qualify. So what does that include? So there are two different things they look at. They're assets that they count towards that. They're counting the value of these assets towards that $2,000 number. So if you have more than 2,000 in cash assets, bank, CD, even joint accounts. Remember we talked about that earlier? So you're joint on somebody else's account. They're going to count that until you prove to them that they shouldn't. That's another reason why joint ownership isn't the best idea. We pointed towards that earlier. They're also going to count the value of IRAs, stocks and bonds, the cash surrender value of like that whole life insurance policy that you have. If you have a cash surrender value, they're going to count the value of that over $1,500. And then any second home or additional properties that you own or a second car, equity in your boat, all of those things, they're going to count all of that towards that number. If all of those things combined are less than $2,000, then you qualify. Here's what they don't count. They don't count the value of any property that you own that's in your name and any property connected to it. If you own the property across the street, they count the value of that. But if you own the lot right next door to your property, they don't count the value of that as long as that property is in your name. Now, there's an asterisk by that. It depends on the value of the property, but the vast majority of people, that rule doesn't apply to. They also don't count household stuff, clothing, jewelry, and all of that kind of stuff. You can have a car. You can still own one car and qualify for Medicaid. So that's not an issue. And then any prepaid, irrevocable funeral and burial policies. Now, for those of you sitting here thinking, oh, my auntie will never qualify for Medicaid because she has, a little bit more than that in the bank and she does have an IRA or whatever. It doesn't end there. That's where you do need an elder law attorney like me or people in my firm to help you get qualified. There are ways you can move the assets around legitimately to get qualified. What you don't want to do is do it on your own because you're probably going to violate one of their very strict rules in doing so. That we typically get that case at that time and they violated it, and then we have to go back and clean it up and do it for them all over again. The last test, though, is the income test. If I can get my slideshow to go. Yeah, income test. Once you've passed the first two tests, then they determine how much are they going to pay. And in order to determine that, they look at the total cost of the nursing facility. We have to submit this in the application when we're working to get you qualified. Then they subtract out all of your income from all sources, any income that you have, including from rental properties, if that works out for you. They subtract that out of the total cost of the nursing facility. Then after that, they pay the difference. They pay the difference between the total cost of the facility and your total income. That's what they pay. So yes, that does mean all of your income has to go towards the cost of the nursing care, except maybe $60 they let you keep. But beyond that, they pay the difference. What happens if your income is greater than the cost of the facility? Well, you probably guessed it. They say, you don't need us to pay it. You can pay it yourself. You have enough income to pay it. And that's how that works. Here, I'm going to stop there. I wanted to go through that pretty clearly. They do take into consideration your debt. I see that question just popped up. I'll deal with that now. Medicaid, when they're looking at that, they do consider your debt, but then again, not really. You got to still pay that debt. So there are certain things that you can pay off prior to applying. So if you have debt, that's one of the ways to get qualified by Medicaid or for Medicaid is by using the cash that you have that pushes you over that asset test to pay down debt. and because you don't want that debt, because you can get qualified and still have debt. Now that's probably where people feel like their house got taken, because all of their money has to go towards the cost of their care. You still got this mortgage to pay for. What do we do? Because they're not going to say go ahead, probably not going to say go ahead and keep paying the mortgage, because they want you to send all your money to them. They would probably push you. They let you figure out, go ahead and sell the house or something like that. So it's tough. That's where you do want to get with an attorney to kind of walk you through the different options that are available, because there's some ways to get around that. There are some ways to deal with that, but you have to do it correctly. The slightest thing that sounds great to you can disqualify. You had a client who had been in a situation like this. He was joint owner with his auntie, and he tried to get her on an account. He tried to get her qualified and pulled all the money out of their joint account and put it in his own. But it turned out they caught that and disqualified him, because that's considered a divestment, because there's an issue around that joint ownership arrangement. So I don't want to go too much into that now, because I do want to spend time on your questions, and we got about 18 more minutes or so. But let's do that now. While I'm going through these questions, you all see this that's on the screen. Please take a look at that. We're all over social media. Just look for TGQ Law. Please follow us. We put out a lot of content, videos and blogs and everything. We're on Twitter, Instagram, and Facebook and LinkedIn. So just find us there. And then there's our website. We have a ton of stuff on our website, all kind of informational videos and all of that stuff. So consider that. On the right side of the screen, you can cut and paste that link or type that link into a browser, or scan that QR code with your phone, and it'll take you to a form that I do hope that you fill out. Chelsea, who's on, will also put that link into the chat so that you can just cut and paste it if you want to. But please fill that form out. Please fill it out. We're not going to harass you because you fill out the form, but we do want feedback from you, and we appreciate it if you did that. All right, let me deal with these questions now. That's what I've been looking forward to. Let's go right from the top. Don't know where to start. Where to start is calling me. Give me a call and let's talk that through. And the way my process works, just so you know, now that you've done this, we don't really need to do what I often do, which is a 15-minute no-cost consult. In that, I'm not giving you answers to what you should do, because I don't know until I look at everything, which takes more than 15 minutes. That's really just a touch base. The things I share in that meeting, you've just learned in this presentation. What we should do is schedule time to do what I call a needs assessment. Let's say that you called and scheduled that needs assessment with my office. Right after that's scheduled, what they will then do is send you an email that has 3 things in it. The first is a link to an article that I authored, where it's a quick read, where I just talk about what to think about in preparation for that meeting. The second thing is a link to a video, which you kind of don't need to watch, because it's a 5-minute version of this, where I talk about the highlights, the major points that were learned in this presentation, but it'll be in that email. The third thing is the most important. That's a data sheet for you to fill out that asks everything. Honestly, you all, I'm the one person in your life who does have to know everything about you, because I can't do my job correctly if I don't know everything we're working with. I need to know all about your family. I need to know all about your assets. I need to know about your health. I don't need to know your blood type, but I do need to know if there are any health things that might help me plan for you in a certain way. So I need to know all that stuff. Fill out the data sheet, send it back to me. We then have the needs assessment and go over that form together. By the end of that meeting, I'm able to tell you exactly what you should have in place. I'm able to make a direct recommendation. I'm also able to tell you at that time exactly what it will cost for me to do your plan for you. So I don't give you a ballpark, which I'm about to give a ballpark, but I don't give you a ballpark. I give you an exact cost for you based on what we've discussed. And everybody's situation is different. I ask for a deposit, typically of half of that amount, to be paid at that time. Here's the benefit of doing it in that meeting. If you decide you want to think about it, which is totally fine, I charge $350 for that meeting because of everything that I've shared and all the time I've spent. If you decide to hire me by paying a deposit in that meeting, I fully waive the $350, so it's not added into the cost. If you think about it, you pay $350. If you call me the next day and say I'm ready, well, you just spent $350 extra, because I still have to charge the same amount that I quoted you yesterday and take a deposit of 50%. So it's a $350 decision at that point. That setup is just fair to me and to you. Where are they filed or stored? Yeah, and by the way, whether you need a will of trust, you will know for sure in that meeting. By the time I tell you that, you'll know why I'm telling you that. If anything, as you can tell, I over-explain stuff. So that happens in the meetings for sure. People typically store their plans at home. You don't have to file it with the court. Some people do. If you're doing a trust, to me, it doesn't make a lot of sense in most cases to file it with the court because we're trying to stay out of the court. But mine is kept in my safe, just so you know. They absolutely do cost money. Oh, I didn't give you the range. Anywhere between $600 and $6,000. Most of my clients are not paying $6,000, but most of my clients also are not paying $600. It's somewhere in the middle. A trust-based plan is going to cost somewhere in the top half of that range, but again, most people aren't paying anywhere near 6,000. A will-based plan is going to be somewhere in the bottom half of that range. Now, for those of you who have MetLife Legal Plan through U of M, you absolutely do want to use that service. I'm not on their panel. However, if you call them and say, hey, I have an attorney who's not on the panel and I want him to do my plan, can you send me the reimbursement paperwork? That's what you want to say, the reimbursement paperwork for an attorney who's not on the panel. Then they will. And they actually pay more towards the cost of your plan when I'm not on your panel than they do if I am. So that's how that works. If I don't have anything of value, yes. So here's why, if you don't have anything of value, you should still do a plan. One reason is because that plan says what you want to have happen with what you do have, even if it's not of value to you. It might be to somebody else, so it directs what should happen. Here's another reason. It is very common for people to have money at unclaimed property, for example, and then your heirs find out, and the only way they can get it is by going to court. And if you don't have a will in place, it may not go where you wanted it to go. Somebody might leave you an inheritance that you didn't know about. And if you passed after they did, but before you were told about the inheritance, that inheritance still has to go to your estate, and your will then govern what happens with it. Last thing for now, the plan is where you identify who will handle business for you if you're alive. So that has nothing to do with valuable assets. That has everything to do with you and your care and your bill pay and all of that stuff. So yes, you need to do a plan. What do I need to include now that my children are nearly adults? Well, my plan says while my kids are growing up, if we pass while they're growing up, use the assets for them to take care of them, including support with college if necessary. Then when they get older, as they get 25, give them some out of their plan. At 30, half of what's left, and at 35, the rest of it. So I'm taking care of them well into adulthood out of this trust in a way that doesn't allow them to just spend everything if for some reason they would or could be influenced to do so. So that's one option. There are all kinds of things you can do. You don't have to do it the way I did mine, but absolutely you want to do a plan to make sure something like that is being covered. Powers of attorney and probate, we covered that. Do I need a trust? If in my will, all my assets go to my estate or my will states division of my, yeah. So we talked, great question. We talked earlier about the importance of a trust. If you want all of this to happen outside of probate court, then absolutely, well, then you probably want to consider a trust. Once we get in the meeting, I'll be able to tell you if you really need one or not. I can't really say now, although I start every meeting with a mindset towards a trust because I know you don't want to be in probate court. The meeting tells me if I should back off of that idea as we're going. We have a small business. Will we be better off with the will only or with the will and the trust? Probably, since I saw this question after talking about wills and trusts, you probably know what I'm about to say. We should start off with the mindset of a trust. And as we cover certain things in our meeting, maybe we'll back off of a will. Off to a will. I can tell you, I'm not a big fan. I think you know by now, I'm not a big fan of will only plans, except where they do make sense. But the meeting is where and that's totally unrelated to the money I make from it, you all. Even in my broke days, and I don't mind sharing this, when I first started this firm in the recession and lost everything, I never recommended anything to anybody, even at that time, that they didn't truly need. I never make a recommendation based on how much money I'm going to make. I make it based on what I know you want to have happen based on what you've told me. So probably you want to consider a trust to start, and then in the meeting we'll figure that out. Had a friend who added his son to his house and bank accounts, and the son clean. Oh yeah, absolutely. Yeah, absolutely. Yes. So the person you add can take it can take everything out of that account, or can have cause a problem on your property, like Charlie's daughter. All right, let's keep on going. We answered the debt question. What if you live with someone and are not married? So this question came while I was talking about Medicaid, but I think I'll try to answer both if you're talking about Medicaid or not. So if you live with somebody and you're not married, again, if I wanted to create a fourth category of people who have to plan immediately, it's the couple that's living together without a plan in place. Before our Supreme Court passed and states passed laws that allowed gay marriage, this was huge for people who are in same-sex relationships, because the law didn't provide for it. And this also applies to people who are in same-sex or heterosexual but unmarried relationships and living together. The law doesn't provide for that person. So if you pass and let's say everybody knew you wanted everything to go to the person living with you, they don't get that stuff unless you have a plan in place. And so everything points back to doing a plan. I don't want you all hesitating or being reluctant to do a plan because you're concerned about cost and all of that stuff. My encouragement is to go ahead and take the step of starting the planning process. You will find, certainly meeting with me, let me just be all the way honest and frank with you all. I see everything that you have. I have to in order to do my job right. So part of my decision is on whether you need a will or trust is based on, can you afford one right now? So I look at that and I say, well, you know what, you really can't. So let's just do a will right now. And then as things adjust, let's go ahead and do a trust. And that's how you want to approach it. However, you also want to understand the ramifications of both in your situation. That's why you meet with somebody who does this for real. If you're talking about the Medicaid situation, if you're living with someone and are not married, that could create problems as well, depending on what you want to happen with the house or where you live and how money is operating. Once somebody goes on Medicaid, all their money has to go towards the cost of their care. Unless they're married, there's a certain amount that does still go to and again, not if you're not married, but does go to your spouse, a certain amount of your income that does go to your spouse. And there's a certain amount of assets, money basically, that can stay with your spouse, although your spouse's assets are also counted in the calculations done for Medicaid planning purposes. Single mom, and I don't want my son to go with his father. But yeah, this is that scenario. Life insurance, and he's only child. Yeah, this is 100% the scenario we talked about earlier. In this situation, almost always, I am certainly recommending a trust, unless you just cannot afford it. And then, we got to kind of tie some things together that might work. The trust will work. And so what you're doing, if they go to their father, that may just be how it has to happen. But with the trust, you're able to put that money in trust and have somebody else govern it completely. And there's nothing the father can do about that. The father would have to go to that person that you appointed to ask for money, and they would have the right to tell him no, or have the right to say yes, but not give it to the father and give it to wherever it needs to go for the benefit of the child. So that's another example of why a trust, without question, in most cases that I experience, are much better than a will. Some of the benefits for having a trust for a disabled child. The number one benefit by far is the child should be able to stay on governmental support and not be disqualified, and still benefit from the assets that you have. As we talked about in that scenario with the Parkers, if you leave it to the children, then they're going to be likely be disqualified from that governmental support. Beyond that, the trust, so the trust provides money of yours, that can be used for the child in ways that the governmental support won't cover. And that's the point of it, right? So, you can set money aside for extra stuff for the benefit of the child. You also that trust can receive money from other people. So other people have a way to send money for the benefit of that child without it disqualifying them. And then if it's set up in the right way, under the right circumstances, when that child is gone, that money won't have necessarily have to be spent paying back the government. Whereas if you left those assets to the child, and somehow then the child, because there are emergency things we can do if the money was left to the child after you passed and then they were in trouble, there are ways that we can put that money away in a trust at that time, but those ways require the government be paid back when the child passes for the money that the government spent. So that can be bypassed or avoided if you've set up a plan on the front end. It should be. So I talked about the U of M legal benefits. Yes, you can use that when working with me for sure. You want to go ahead and contact MetLife now and tell them that you're going to use an attorney who's not on the panel. They'll send you an email that'll have about 6 attachments. And then when we meet, you'll just forward that email to me and then we fill it all out like it's supposed to. And to talk about end of life, if you're in a coma, then what do you need to consider? Well, you want to consider it before you're in a coma. I understand the question. Well, you want to definitely, this is why you have to do it now, because we never know when and if a coma will happen. So you want to make sure a plan is in place now. I know I'm talking fast, y'all. I'm trying to get through it before my time is up. You want to make sure you have a plan in place that covers that, where you answer all these questions so that you're in control what happens if you ever go into a coma. Once you're in a coma, it's off the table. The only way anybody can do anything for you is by going to court to get conservatorship. And remember, we talked about that process and how much fun it is not. So that can be avoided by a properly created power of attorney and healthcare power of attorney. And you all, I'm gonna just say it. I do not recommend online documents. I do not recommend online companies. I'm not going to name them here. I do not recommend a lawyer who does not truly specialize in this. If I had more time, I'd give you a story why, but I don't have time. Give us a call. We can create it correctly and everything will be tightened up. Who enacts your trust will if you pass without family? Hopefully it would be whoever you've appointed in the document. So I always encourage that you have 3 people, a main person that you've appointed, a backup, and then the backup to the backup. Because I've lived through the scenario where the backup to the backup has had to act now because the other 2 died. So, we should consider who should be there in addition to your family in that list. If the people that you listed are all not alive or can't do it, then the beneficiaries of your trust or the court will select somebody, which kind of goes down to this next question. What are my thoughts on appointed trust companies, basically trustee companies or non-family members acting as PR and all of that? I think it's good if you need it, but I typically try to encourage people to appoint somebody that they like. These companies don't really know your family or how you operate it, so they may do stuff that you wouldn't have wanted done because they have a lot of discretion. The other reason is because the companies are going to charge a big fee. Now, even your family member trustee can charge a fee, and you can't write that out of the trust. But oftentimes, that family member doesn't even charge a fee. I know you're the beneficiary of a trust set up by your uncle, passed. You don't think they're acting the best. Yeah. So going on 3 years and probate, even with it. Yeah, that's what. Yeah, that can happen. So if your trust is tightened up in the right kind of way, that can be avoided, or you get closer to ensuring that this kind of dragging on will not happen. I would, give me a call if you want to. We kind of talk through what's going on, and I can give you my thoughts on how you might be able to do something about what's going on right now in court. You may have to just wait it out, but at least we can talk about it, and I can give you my thoughts about it. We answered that question. The form for U of M legal benefits, you want to call MetLife and tell them you're going to use an attorney who is not on their panel, and you need the reimbursement paperwork. Again, they're going to send you an email with about 6 attachments. Just you look through it if you want to, but just hold on to it. And when we meet, make sure you get that. Tax benefit to beneficiaries when assets are passed them via trust versus a will. I don't really have a lot of time to go into this too much, but the answer is assets typically are not taxed when they pass to your beneficiary unless they're a type of asset that has to be taxed no matter how you pass it to a beneficiary. So, for example, most of you all probably have a 401a, 403b with U of M. Most of my U of M clients do, either through TIA, CREF, or Fidelity. Those accounts, for example, as an example, are taxable accounts. And so whenever money comes out of them to you or to anybody else, it's going to be taxed. If we put them in a special kind of trust that I can create, too deep to go into right now, then you could govern how and when the tax happens. If it happens through a will, it's going to be taxed. Now, the problem with it going through your estate, which the will govern, is then you have the court costs, the time, cost, and publicity that we talked about. So if you have to use one of these two to pass it on, and that's a big if, um, then the trust is probably going to be better. But that's definitely a conversation we need to have. That's a great question. One wants a plan in place for their parents. Can kids plan it for their parents, or must it be done? It has to be done by the parents. Great question. I can't do a plan for somebody unless I talk to them. They sign off on it. And honestly, I put everybody out the room when it's time to talk to them. You can bring your parents. It happens all the time. But there's a portion of the meeting where I'd ask everybody to step out and I have to meet with the parents alone. And that's the protection of everybody. Well, you all got a lot of questions. This is good. Well, we're pretty much done. When or how often does a will need to be updated? Great question. I was trained to say every 3 to 5 years. Now in practice, though, I know that's not enough. I meet with my clients annually to make sure their plan is up to date, kind of like a doctor's checkup to make sure you're healthy. You want to make sure your plan is healthy. And so that's important to do. And honestly, your estate planning attorney should be in your life throughout the year. As things happen, your attorney should be available to you. I don't send my clients a bill every time they email me about something going on. I'm not that guy. Nobody ever owes me money until they know that they're going to owe it because they knew I was going to do whatever they agreed to pay for. Um, so this is how your attorney should really be operating if he or she is working with you correctly. All right. I am going to, can I stick around for a couple minutes? Yep, I'll stick around for, yep, no problem. We're done now. We're going to stop here. I want that to show up. If you all would, I'm asking again, please scan that QR code or go to that link. I think I saw it in the chat. Please, please do that. Fill out that form. It's quick and easy. It'll take you 5 minutes to fill it out. Please fill that out. We will follow up with you. We will not harass you. My last statement before I say I'm done is I encourage you all, please, even if you do not use me, I won't be offended. I'll be sad, might cry a little bit, but I won't be offended. Please, please, please do not let April end and you have not completed your plan. Please do this right now. It is that important. I say this now in all of my presentations because I see it all the time. Don't let a month pass and you haven't finished this. Just take care of business. You will be glad, and maybe more importantly, your family will be glad that you did. Thank you all so much for your time. Center for Education of Women, Women of Color Task Force, thank you for allowing me to do this today, to share this information. It's my pleasure. You all will see that the form asks, is there an organization or place where you'd like me to share this info? Please put it in there when you fill it out. I'm trying to get everywhere. So thank you all so much for your time. And you all have a great weekend. Be safe because it has changed since this presentation. So be safe, and I hope to meet you all. Thanks.
Thank you so much. Thank you so much for the session, and thank you for the great information. I just
My
wanted to
pleasure.
base with you and kind of ask you, how would you like for me to proceed with like the information, the links? Because once like oh, let me stop recording, sorry.